Dear students, today we are going to start a very important topic, that is narrow analysis of muscular movement, or technically we call it the actus reus. Actually, we have studied that what we call the muscular movement. If there is muscular movement, then definitely there is command from the brain. And if brain is commanding something, then definitely our hand or our leg or any body part would do something. So muscular movement are basically of two types: willed muscular movement and unwilled muscular movement. If it is willed muscular movement, then definitely the act done by the accused was a wrongful act. If it was unwilled muscular movement, then there is a saying that act done on the direction of other is not my act, or act done against my will is not my act. So therefore, if there is unwilled muscular movement, then we cannot call it actus reus, or the wrongful act, or the guilty act. So to understand that what we call actus reus in detail, we must take an example of section 378 of the Indian Penal Code, that defines the term the offence of theft. As per section 378 of the Indian Penal Code, there are 6 ingredients which has to be proved by the prosecution beyond all reasonable doubt. Number one, there must be dishonest intention. Number two, he takes the property. The property was a movable property from the possession of another person. You must keep in mind while you are studying the offence of theft that it is an offence against possession and not against the ownership without the consent of that person, and he removes that property. Now the question is, what is actus reus and what is mens rea out of these 6 ingredients? So as per section 378, the dishonest intention, the accused removes the property with a dishonest intention. So here the dishonest intention is a mens rea, and removal of property is actus reus. Now a question may arise, then what are the other 4 ingredients? If actus reus and mens rea both has been proved, then why there is need of other ingredients? So section 378 defines the offence of theft, and it includes the six ingredients. So all the 6 ingredients has to be proved by the prosecution beyond all reasonable doubt. If any ingredient has been left out, then the accused cannot be punished for the offence of theft. So here the other 4 ingredients are basically the state of affairs. For proving the offence of theft, the actus reus, the mens rea plus the state of affairs has to be proved by the prosecution. Now come to another point, that uh, in an offense, what are the two important things? So in an offense, you must see that there is actus reus and the mens rea. As we know that actus reus is the external element of crime, or the physical element of crime, whereas the mens rea is the internal element of crime. Why it is called external element of crime? Because anything which exists outside of human beings here means the accused. So anything exists outside of the accused body is called the external element. Now I may ask you a question, that what is the consent of the rape victim, whether it is an internal element or whether it is an external element. The consent of the rape victim is basically external element, because it exists outside of the accused. Of course, it exists in the mind of the victim, but it exists outside of the accused body, accused mind, and therefore it is an external element of crime. So basically, in actus reus, or the external element of crime, there is willed muscular movement. If it is unwilled muscular movement, then basically it is not a crime. It is not an offense done on the part of the accused, because the act was done against the will of the accused. Point number two, there must be cause and effect. We have already studied there are 3 types of cause and effect: direct cause, remote cause, and the proximate cause. Direct cause are those cause where there is a direct effect of the act, Remote cause are those where there is a time gap between the act and the effect, and the proximate means a reasonable man can foresee the consequence. And number three, the state of affairs. That state that we have already studied, that state of affairs has also been proved by the prosecution beyond all reasonable doubt. Now come to the point, the internal element of crime, that is mens rea. We also call it the intention, and here the mens rea includes the knowledge. Although there is distinction between the mens rea and knowledge, we will study later that what are the distinction between the mens rea and knowledge. But intention and knowledge. But for the sake of mens rea, we must understand that intention and knowledge both are mens rea. So here, the mens rea includes the intention, knowledge, recklessness, and negligence. These are the some internal element or the mental element of crime. So, the intention is always dependent over the context. What does it mean? Here, suppose a person having an intention to extract money, and therefore he took an aircraft with 20 passengers, and he fixed time bomb in the aircraft, and he took away the aircraft. So what was his intention? His intention was not to kill the individual, rather his intention was to extract the amount from the government or from the other agency. So therefore here the intention is not to kill, here intention is not to cause death. So therefore intention is always dependent over the context. Now we must understand that what is distinction between the intention and the knowledge. Here intention is something which exists inside of human being, which cannot be verified by the external source of information, which cannot be verified by the external source of information. Whereas knowledge is something which exists outside of human being and which can be verified by the external source of information. For example, if I say you are the student of second year student, and that means it is not something which exists inside you, rather it can be verified from the director's office, it can be verified from the registrar office or the vice chancellor's office. Anyone can approach, anyone can file an RTI before the university and can take your information that whether this particular individual is studying in BLLB second year or not. So knowledge can be verified by the external source of information, and the knowledge is objective in nature, whereas intention is subjective in nature. Subjective means which cannot be verified, which is available inside of human being, and whereas knowledge is objective in nature and that can be verified by the external source of information. Now come to another important aspect of the intention, that what basically intention is. If we call that he is having an intention to kill, then in that situation three things has to be proved. Number one, accused had desire of consequence. Number two, for that desire he followed the course of conduct. And the number three, accused could foresee the consequence. Now, what are these things? The accused had desire of consequence. What does it mean? The person, for example, let us take an example. You are sitting in your hostel and you are thinking that this particular individual is my enemy and I have to teach him a lesson. I will kill him or I will cause hurt or grievous hurt. In that situation, you have a desire of consequence. Consequence is the final result, the death, the grievous hurt, or something else, or some other offenses. So you have a desire of consequence. Point number two, for that desire, you followed the course of conduct. What does it mean? Here, you are going to do something, means something towards the commission of the crime. You are doing some act towards the commission of the crime, although it is not a mandatory ingredient of intention, but you are doing something so that the intention, how intention would be proved? If you are thinking in your mind something that cannot be proved, that cannot be verified by the external source of information, and again you cannot be punished on that ground only. So therefore you have desire, therefore you have desire, and thereby you follow the course of conduct. That means you did something towards the commission of the crime. And number three, accused could foresee the consequence. What does it mean? If you are doing something, that means you could foresee, if I'll do these things, then definitely this would be the consequence, and therefore the accused could foresee the consequence. Let us take an example that A opened fire over B and the B died. Here the question is whether A intended to kill. Of course, he opened fire and definitely he intended to kill. Whether A is having desire, definitely if he opened fire, then he is having desire to kill. Whether he followed the course of conduct while pressing the trigger of the gun, he followed the course of conduct. So he could foresee the consequence. He is having desire of consequence, and thereby he followed the course of conduct. So what we understood, if I'm saying that there is intention to kill, or someone is having an intention to cause an to do an offense, then in such a situation, three things has to be proved: that the accused is having desire of consequence, he followed the course of conduct, and the accused could foresee the consequence. Now, if suppose he opened fire over B, and if he says that I opened fire just because of flower, or just because of 1 rupees or 2 rupees or 5 rupees, what does it mean? He is having unsound mind, or the person is of unsound mind, and he don't have a reasonable mind, and therefore he can be exempted from the criminal liability as per section 84 of the Indian Penal Code. That we will study later, but he could foresee the consequence. Then in such a situation he shall be punished for the offense. Again, let us take another example. Suppose there is traffic and you are moving by your car with the speed of 100 kilometers per hour. For example, there is Connaught Place in Delhi. It's a very busy area, and where someone is moving his car with the 100 kilometer per hour of speed. Then in such a situation, if suppose if he hits someone, then definitely he causes death. And in such a situation, he could foresee the consequence. Now the question is whether he could foresee the consequence, whether he followed the course of conduct, and whether he is having desire of consequence. Here he could foresee the consequence, he followed the course of conduct, but he was not desire of consequence. Why? Because he might have in hurry. So therefore he don't have desire, and therefore we cannot call it an intention to cause death. So, in a speed car example, the person in that case, the desire is missing, but the foresightness is present, and therefore we cannot call it an intention. Let us take another example. A want to take out the purse from the B's pocket, and for in that course, while taking out the purse from the B's pocket, the B died. Whether A had desire to kill, of course he had desire of theft, causing the committing the offense of theft, but he don't have desire to kill. Number two, whether he followed the course of conduct. He didn't follow the course of conduct. The reason was he followed the course of conduct for the theft and not for the killing B. And whether the prudent man can foresee the consequence, whether an individual can foresee the consequence, that if I will put my hand into someone else's pocket and he will die. No, a prudent man cannot foresee the consequence. So even though he was taking out the purse from the bee's pocket, he shall not be punished for the offense of killing, for the offense of murder. Rather, he shall be punished for the offense of attempted theft. Now the question is that if the desire is missing and foresightness is present and he followed the course of conduct, then whether he cannot be punished of course he shall be punished. But for that we have another term called recklessness. Uh, Here the recklessness is having it is basically one of the types of the mens rea, but it has less culpability than intention and more culpability than the negligence. Recklessness is having less culpability than intention and more culpability than the negligence. What does it mean? Here we can project ourselves into the future. We can project ourselves into the future, and while projecting ourselves into the future we can foresee the consequence, that what would be the consequence of our act, but we didn't desire to do that act. So here in this case what happens, the person, the act was done on the part of the accused, and therefore he has taken the risk. The act has been done on the part of the accused and he had taken the risk, and that risk taking may be either latent risk or the patent risk. Patent is something which is visible, which can be foreseen by the any individual, and latent risk is something which cannot be foreseen by the reasonable man. So in this case, there is foresightness of consequence, but there is undesirably risk taking by the individual. What does it mean? Normally, it involves the consciousness. Here, with his own conscience, he has taken the undesirably the risk, and therefore the person would be responsible for the offense of recklessness and not for the intention of causing death. So here now the question is, when he has taken the risk, whether that risk is justified risk or unjustified risk. Suppose the risk was unjustified, then definitely he shall be punished. Now if suppose the risk was unjustified, suppose the risk was taken by the individual and it was a justified risk, whether it was uh, for himself or for the society. So, if suppose stop, someone stopped his car at the crossing, and to save the petrol, he switched off his van, and during switching off, during that process, van, the vehicle got exploded. So, he had taken the risk, and it was definitely there was a utility, and it was beneficiary, but it was for himself and not for the society, because during explosion 2 3 people died. But here the justified risk taking may be for the societies as well. For example, a doctor operates over the patient knowing that he may cause death of the individual. In such a situation, the doctor is also taken the risk, but he has taken the risk for the society and not for himself. So, in that recklessness, he may be exempted from the criminal liability. So, here the doctor had also taken the risk not for himself but for the society. Thank you very much. I take into consideration that you have understood that what we call intention and the act, or the actus reus and the mens rea. In our next lecture, we will study what we call recklessness and the negligence with the help of the other cases, landmark judgment. Thank you. Thank you very much.